Well, first I must confess that my PhD was in law, so I'm expecting some more engineer lawyer jokes. I want to start off with a quote from Eric's talk. I think he just left. He said, "And nothing creates more paranoia than changing the legal rules." Now, this is a pretty strong quote, I think, and it leads to the significance legal rules have in arid regions. I'm exactly interested in those changes in my talk. I want to discuss with you or present to you some of the legal dimensions of the groundwater revolution and implications at the beginning of the 21st century, as there are signs of groundwater crisis in many areas of the world. My talk is a comparative study. I will look at Arizona and Jordan, so very different countries, right? Probably more than an ocean that divides the two. However, my first starting point are the arid conditions that are both in Arizona and Jordan. We have seen a sharp increase in the use of groundwater since the beginning of the 20th century. This has been termed the groundwater revolution. This has led, however, in both countries, in Arizona and in Jordan, to a groundwater crisis. With the symptoms of which we have talked a lot about in the last few days, groundwater depletion, overdraft, quality degradation, and etc. The second level of my comparison is the very different political and social context of groundwater law in those two countries, in Arizona and Jordan. Now, Arizona, of course, is a long-term democracy with an advanced economy. Jordan, on the contrast, is ruled by an autocratic king, and its economy can probably best be described as a rentier state, which derives major parts of its income from abroad. Now, I'm going to take you on kind of a long journey. The period I'm covering is from the mid-19th century to about the beginning of the 21st century. However, I want to limit myself to two instances in this development. The first one is in the mid-19th century, and the second one in the second half of the 20th century. And I want to argue that in those instances, there were transformations in the groundwater law that had major effect on the way groundwater was dealt with in the two countries. And those changes in the law is what I think, what I want to argue is that in those changes in the law, there were different. There were, first of all, similar aspects in Arizona and Jordan. There were surprising parallels in the evolution of groundwater law in the two countries. However, and the major difference in the two countries was the motivation for those legal changes, especially the role of the state. So the first transformation occurred in the mid-19th century, and this was a transformation from the traditional legal concepts that governed the access and use of groundwater until this time to modern concepts. In the legal concepts that existed up to the 19th century, there was an understanding of groundwater reflected as a communal resource that was open to use for everyone. However, the traditional concepts were conservative in a sense that they favored the preservation of the status quo against a expansion of groundwater use. This was changing in the 19th century, and this change in the legal concepts allowed for much more groundwater to be used in the decades and century ahead in the 20th century. Now, in the 1860s, Jordan was not a state yet. It was until the First World War a part of the Ottoman Empire. However, the Ottoman law of the late Ottoman Empire had much influence on Jordanian law after the state was created. And the transformation I was talking about from traditional concepts of legal norms to modern concepts was reflected in the Ottoman Civil Code, which was drafted in the 1860s. And at the core of this transformation was Article 1194, which linked the use of groundwater to the property in the overlying land. So very much like Eric was talking about, which is still in common law, but I'll come to that in a bit. Now, 1194 read, whoever owns a piece in land in absolute ownership is likewise owner of what is above and what is below it. And the article expressly stated also, or referred to the use of groundwater, as it said, he may also dig wells as deep as he wishes. This is a translation, contemporary translation I'm citing here. Above you can see the Ottoman Turkish version of this article. Now, the background of this transformation in Ottoman law is kind of unique because at this time in the mid-19th century, the revolution of groundwater use hadn't occurred yet in the Ottoman Empire. Most wells must have looked like this one I'm picturing here. So traditional wells that were used for watering livestock or for domestic purposes. What is significant about this transformation in the Ottoman Empire is that the legal norms changed before the use of groundwater changed. And the background to this was that the Ottoman government tried to develop the Ottoman Empire because it was lagging behind the European powers. And this way of fostering the use of natural resources, for example, groundwater, was a way to develop the country. Now in Arizona, respectively the common law, the Anglo-American common law, a similar transformation happened. But I want to argue that this transformation was in a totally different, or in a different context. The first decision of the Supreme Court of Arizona on groundwater was Howard versus Perrin in 1904. However, this decision of the Supreme Court was closely linked to the development of groundwater law that had happened in the common law in the decades before. And with regard to groundwater, the landmark decision in common law was Acton versus Blundell of an English court in 1843. And now I want to point out the similarity that existed between common law system and the Ottoman article I just pointed out to you. Because in Acton versus Blundell, the English court wrote that the person who owns the surface may dig therein and apply all that is there found to his own purposes at his free will and pleasure. So we have this concept of absolute ownership, which also goes down until the groundwater, and the use of the groundwater also reflected in this common law decision. Now, between Howard and Perrin in 1904 and the Acton versus Blundell, there were of course more than 50 years during those half century, the concepts had evolved, and the Supreme Court of Arizona adapted this absolute ownership doctrine. However, it modified the legal rules to fit the conditions in the Southwest, and this was mainly in implementing a bifurcation between the absolute ownership doctrine, which referred to so-called percolating groundwater. On the other hand, the court thought that there was a second category of groundwater, so-called underground streams, and those were governed by prior appropriation, which was the legal concept that also applied to surface water streams. The background to this was that in Arizona, at the end of the 19th century, the surface water was already far developed. So this served to protect, I would argue, the surface water stream. With respect to groundwater, this wasn't, at least in 1904, not necessary yet, as there was at this time only a few wells in Arizona. So with regard to this first transformation, there was, with regard to the legal concepts, we have a parallel between Arizona and the Ottoman Empire. However, the context in which this legal transformation happened was a lot different. Now, I want to take you about 50 years further, so be prepared for a little bit different aspects now. The second transformation of groundwater law in what was now Jordan and Arizona happened in the second half of the 20th century. In between, of course, the use of groundwater, especially in agriculture, had increased a lot. One other feature, and that's what I'm trying to depict here with the two pictures, was the increase in the in urban population and the increasing use of groundwater in urban areas, which led to a conflict between agricultural use and municipal use. This second transformation was one of state intervention, as I want to call it. And the dominant feature of this transformation was that state institutions gained competences with regard to the management and governance of groundwater. Now, in this transformation, there is a surprising parallelity in the evolution in the law in Arizona and in Jordan. It followed three steps in both countries. The first one was in Arizona, the Groundwater Act of 1945, which in Jordan it was a groundwater bylaw in 1961. In Arizona, this Groundwater Act was limited to data on groundwater wells and groundwater use. In Jordan, it went a lot further by implementing a permit system for groundwater use. And this reflected a different attitude towards the role of the state with regard to the utilization and governance of groundwater. In Jordan, this continued from the Ottoman Empire, I would argue. This attitude towards a stronger state was much stronger than in Arizona. The 1948 Groundwater Code is reflected in the 1997 bylaw. In both laws, there were regulations towards critical groundwater areas where the expansion of groundwater use was restricted. And the final aspect is in 1980 and respectively in 2002, two laws that where the concept of safe yield is at the center. I'm glad that Sharon kind of laid out all the details about the Groundwater Management Act. So I can refer you back to her paper because that's so complicated stuff. However, I want to point out that the Groundwater Management Act was much more detailed than the law in Jordan. Both, however, go towards this goal of safe yield, as I said. Now I'm coming to the end of my presentation. I've pointed out the two transformations in groundwater law in Arizona and Jordan. The process, the evolution of groundwater law seems like a process of trial and error. There were in between many legal concepts were tried out and then dismissed again. The drivers of this constant change were the changing conditions of use, and also a point that I think was really important, advancements in hydrogeology, because a lot of times along this evolution it was argued that the legal concepts were not in line with the hydrogeology. So this was a strong argument to change the legal rules. I pointed out the parallels in Arizona and Jordan. It's pretty obvious, however, that there were fundamentally different motivations for these legal changes and legal reforms. Thank you very much.
I was very intrigued by your title because I've done some work in Jordan, and I believe in looking at different areas of the world with similar circumstances and see what you can draw from that. So I'm wondering, from your study, do you have anything you'd bring forward to say, well, these were some good things that emerged out of two very different settings that could carry over elsewhere? Or, you know, kind of, are there some similar best practices? Are there something you could take to another area and say, you know, here are two very different areas of the world, but they're doing some things similarly, and you should consider doing that too? Is there something like that?
Yeah, as I said, I would consider the Groundwater Management Act much more detailed. Most of the concepts in the GMA go further than the laws in Jordan. So I wouldn't consider the legal system in Jordan as an example for other regions in this way. In this sense, I can't really lead you to best practice examples from Jordan in that sense.
Right. So are you saying it maybe the less detailed law was easier to work under, or vice versa? The Jordan is preferable? The other way around?
Yeah. I mean, Jordan has, maybe I can just quickly put, no, it's already gone. Jordan has unique problems. I was reminded of that by the talk of Osvaldo, who said that 70% of the wells are illegal in parts of Brazil, and that's also a huge topic in Jordan. So if you think about it that way, you're going towards, you need to consider the legal culture in which the groundwater law in Jordan is happening in contrast to other countries. So what might be in the law needs to be understood in this concept, in this context where in Jordan there's a legal culture where the decisions are being discussed a lot more than in other countries, Germany, for example. So this still doesn't mean that they don't play a role, but in each individual case, there's much more open to find a consensus, to discuss the things with regard to each individual, maybe.